All right, let's dive right in. We're going to talk about a really critical modern issue, this constant push and pull between law enforcement needing our digital data and our fundamental right to privacy, right here in India. Honestly, it's a debate that affects every single one of us with a smartphone.
I mean, just think about it for a second. Every little thing you do online, a text you send, a photo you store in the cloud, it all leaves a digital trail. The real question is, who holds the keys to that trail? And what rules do they even have to follow to use them?
So, at its heart, this is a classic balancing act. You've got security on one side, the need for law enforcement to do its job and keep us all safe. And on the other side, you've got our personal liberty, the right to keep our digital lives, well, private. In today's hyper-digital world, pretty much every digital interaction creates data. And for modern law enforcement, that data has become an absolutely crucial resource. It's just as important as any other kind of evidence when it comes to solving crimes. So, how do they get their hands on it? Well, that brings us to the actual legal tools, the so-called digital keys that authorities use to get access. Let's break down how it all works. The main tool in the toolbox is Section 91 of the Code of Criminal Procedure, or the CRPC. You can think of this as the master key. It's the legal power that lets a court or a police officer issue a formal written order demanding access to documents or data for an investigation. And there are basically two ways this can happen. Path number one, a court issues a formal summons, which means there's some judicial oversight. Path number two, a senior police officer just issues a written order directly. So you see two very different routes to get to the same exact place. And what kind of data are we talking about here? Well, it can be pretty broad. It's not just your name and phone number. It can be your subscriber details, your metadata, that's who you called, when you called them, for how long. And yeah, sometimes it can even be the actual content of your private messages and emails. Now, that's for data that's already stored somewhere. But there's another more active form of surveillance called lawful interception. This is when the government gets the green light to monitor your communications, your calls, your emails, your messages, as they're happening in real time. But of course, a power like that isn't supposed to be unchecked. The 2024 rules put some safeguards in place. For instance, interception is meant to be a last resort. The orders are time-bound. They can't go on forever. They have to be specific to a person or a place. And crucially, there's a review committee that's supposed to provide oversight. These are the checks that are built into the system. Okay, so even with those rules on the books, you can see how this kind of power raises some pretty serious ethical questions, right? This is where the legal theory bumps up against some very real-world concerns. And this table here really lays out that tension perfectly. The power to get into your messages, it helps investigations. The risk, you might never even know you were being watched. The power to make broad data requests, sure, it's useful. But it also means they could collect personal data that has nothing to do with the case. And the secrecy needed for national security, it means there are very few ways for a regular citizen to stand up and challenge one of these orders. So that brings us to the first big red flag people point to, a lack of truly independent oversight. Sure, there are internal review committees, but there isn't really broad supervision from an outside body, like the courts or parliament. You kind of have the executive branch overseeing itself. Red flag number two is all about transparency, or the lack of it. There are these huge government surveillance programs, like the Centralized Monitoring System, or NotGrid, that connects all these massive databases. But they operate mostly behind a curtain of secrecy, so it's pretty much impossible for the public to know just how widespread this surveillance really is. And finally, red flag number three, the risk of misuse. There's a genuine concern that these incredibly powerful tools, which were designed to stop crime and terrorism, could be turned to other purposes. Things like monitoring political opponents, activists, or journalists. So, With all these risks on the table, what's the path forward? The goal isn't to just get rid of these tools entirely, but to figure out how to strike the right balance and use them responsibly. So, what does a better system look like? Well, experts suggest a few things. Instead of broad requests, you minimize the scope of the data. To fix the oversight problem, you bring in tough external audits. To deal with the secrecy, you have the government publish regular transparency reports. And to empower people, you create clear legal paths for citizens to actually contest these orders. This quote just nails it. At the end of the day, having informed citizens who know what's going on and having transparent institutions, that's our best defense. It protects us from crime and it protects us from government overreach. And that really leaves us with the big question that every society in the digital age has to answer for itself. There are no easy answers here, but it's a conversation we absolutely have to keep having. In this fight for security, just how much privacy are we really willing to give up?